Hi, I'm Marshall Carter, and today I'll be arguing why it's a good idea for employers to use a written employment contract. So, written employment contracts are beneficial for both the employer and the employees. I'll start off by asking a question. So, since there's no legal requirement to have an employment contract, and especially a written employment contract, why spend all the money to have one professionally drafted? My purpose today is to prove that written employment contracts are a good idea to use in the workplace. So first of all, what constitutes a good written employment contract? Written contracts can mainly be basic in a lot of organizations and industries. They should consist of an offer letter of employment, a setting out of key terms and conditions, and this includes salary, benefits, start date, job title, job duties, and a termination clause. So I'll acknowledge that several points in this presentation have come from exterior sources, so I'd like to give credit to those sources now. I would like to credit the Nolo Legal Encyclopedia, Edmunds Employment Law for Business and Human Resource Professionals, as well as the HGR Graham Partners LLP for the purpose of this assignment. All right, so why is it important to have a written employment contract in place? So first of all, they reduce the risks for misunderstandings. They specify the rights and obligations of both the employer and the employee. They reflect a common understanding of the terms and conditions of employment that can always be referred back to. Written contracts reduce the risk of misunderstandings that could possibly lead to lawsuits and disputes later on down the road. They also address potentially contentious issues early on in the employment relationship. They encourage the parties to deal with these potentially contentious issues early in the relationship because both the employer and the employee have a strong incentive to reach an agreement that is mutually satisfactory. So contentious issues are likely to be dealt with in a constructive manner because of this. Written employment contracts also reduce uncertainty. So if a dispute reaches the court, a well-drafted employment contract can provide the court with a clear record of terms and conditions of employment. So now I'll provide a little bit of contrast to that point I just made. So I'll look at oral contracts briefly. So in comparison, if there's a dispute, both parties are going to have to try and justify their opinion and their side and prove to the court which side is more true. So having that written employment contract will provide for that written backup so the employer can justify its point to the court. So written employment contracts can also contain confidentiality clauses, and these prevent employees from disclosing information and using thus information for personal gain. Written employment contracts give the employer more power. They do this by giving the employer control over the employee's ability to leave the business. In the written contract, you can specify work terms. You can keep good talent within your organization for that specified amount of time. So example, a 2-year work term. They can also require the employee to give enough notice to find a suitable replacement, enough time to also get the employer to train that new employee. Employers can insert non-competition clauses in the written contract, and this prevents employees from directly competing with the employer after the employment relationship ends. Performance standards can also be clearly outlined, and grounds for termination are explicitly established. This gives employers the opportunity to terminate employees that are not meeting the required performance standards. So this brings me to my final point in this argument. If there is no written employment contract in place, several things can happen. So employers may be subject to poor performance. Grounds for termination are explicitly established, which gives employers the opportunity to terminate employees that are not meeting the required performance standards. So if there's no written contract in place, poor performance may have to be tolerated. There's also no way to have a non-competition clause without a written contract, and this also places the employer in a vulnerable position. So, after all of these considerations, I say that it is a good idea to have a written employment contract in place from the employer's perspective. Thank you.